Well, good evening, everybody. I'm Richard Salter, I'm the reader of the Inn, and I'm very pleased to welcome all those who are here this evening, not merely those who are with us in the room, but also those who are with us online, to this, the International Judicial Summer Lecture organised by the International Relations Committee of this Inn. I'm very, very pleased to be able to introduce our speakers this evening. To my right, we have Judge Prateek Jalan, a judge of the Delhi High Court, who's going to talk to us about the growth of commercial litigation in India in the last decade. On the far side of the panel, we have Ritin, senior advocate, who is a door tenant at 7 Kingsbench Walk, who's going to tell us about practice as a senior advocate at the Supreme Court of India. And on my far left, we have Chintan Chandrachud from Britcourt Chambers, who is going to talk about India-related arbitration seated in England. We hope that Krishna Vora from 39 Essex Chambers will be joining us shortly, also to speak about insight into English and DIFC cases with Indian elements. But we have an interesting panel in front of us. I ought to begin with some housekeeping notes, if I may. First of all, this event is being recorded and will appear on the Inner Temple website in the coming week, and a link will be sent to all guests afterwards. Please can I ask everybody, not merely in the room but elsewhere, to ensure that their mobile phones are switched off or on silent. Students and those requiring qualifying session credit must sign the sheet in the reception area before leaving, or you may not be given your credit. This session is not a qualifying session for those who are not Inner Temple students, but practicing barristers, if they want to record it and their CPD, should keep a note of what we've been talking about. At the end of everybody's speeches, there will be an opportunity for those here in present, as well as those attending online, to ask questions of our panel. Members of the audience in the lecture theatre should indicate that they wish to ask a question, and a microphone will be brought to them. You need to have the microphone, not because I won't be able to hear you, but because those online will not be able to hear you. So we need to make sure that the sound gets into the microphone as well as into the room. Members online should use the Zoom webinar to submit questions at any time during the presentations, and then they will appear on the magic screen in front of me, and I will ask them here of the panel. Questions can, of course, be addressed to any individual panellist or the panelists as a whole, but please try to keep them concise and produce single-part questions, as this will allow our panel to cover more ground. The Inner Temple is very proud of its connections with India. I should say connections with modern India, because we had a fairly turbulent relationship at the turn of the 19th century and the beginning of the 20th century prior to partition. But in modern times, we have done a lot of things in India. I myself have had the privilege of working in India. I have helped to write the script of Distinguished Senior Counsel for cases in front of the Mumbai High Court and then in the Supreme Court in Delhi on appeal. Not, I might add, that the Distinguished Senior Advocates ever actually followed the script that we did. And I've also had the pleasure of arbitrating both in Mumbai and in Delhi, and in visiting various other places for consultations, and I have really enjoyed it. The one thing, however, that I tell everyone is that although Indian law is extremely familiar to English lawyers, because it is English law with a number of experiments that the English decided to give to the Indians at the end of the 19th century, like the Indian Contracts Act and things like that, where we were thinking of codifying our own law. Actually, the similarity is largely misleading, that on the whole, Indian lawyers think about English statutes or statutes derived from English in a way which is different to the way English lawyers would speak about it. They have their own approach to these things, and it's always very, very instructive to hear how a different culture thinks about statutes and commercial problems, because I was dealing with commercial cases, essentially banking cases, from a different perspective one can learn, and there is great opportunity opportunity for cross-fertilization between the two. The last treasurer of the Inner Temple, Sir Robert Francis, went to the Commonwealth Lawyers Association conference in India in 2023 and gave some speeches and very much enjoyed that. And we are very, very grateful to those who are giving up their time this evening to further to cement that very strong connection between the Inn and the Republic of India. Well, I will stop talking now and hand over, if I may, to Master Prateek Jalan to give us our keynote address.
Thank you, Master Reader. Very good evening to all of you, Master Treasurer, other Masters of the Bench present here, my distinguished panelists on the who will be speaking this evening, and to all the members of the Inn and students, ladies and gentlemen. It's a great pleasure and honor to be invited to deliver the first international judicial lecture by the International Committee of the Inn, and I'm most grateful to the International Committee and to Master Kieran Beale, whom I'm honored to see here today, for this opportunity. Master Reader spoke just now of the long association between modern India and the Inn, and with gratitude I borrow that phraseology because I think it reflects very correctly the ethos with which I hope we approach further cooperation between India and the Inns of Court, particularly, of course, my own inn at the Inner Temple. So that is the approach with which I join you today. And I think the beginning of an international judicial lecture series really reflects the Inn's modern approach to training and advocacy, training and education of barristers, which of course is the core of its mission. In an increasingly globalized world, the connections between different jurisdictions and different countries require appreciation to really provide the services for which our profession is noted around the world. So I'm most grateful that the International Committee has thought it fit and appropriate to start such a lecture series. The subject which I have chosen in consultation with Master Beale is the growth of commercial litigation in India over the last decade. You will appreciate that commercial litigation is often one of the first frontiers of transnational dispute resolution, and is, of course, as old as international trade, but also provides new challenges at every turn of time, which give us opportunities to think afresh about the ways in which we can learn from each other's jurisdictions, cooperate and collaborate. I dare say that what Master Reader pointed out about the commonalities and distinctions in our two systems, to an extent, is only accentuated as we move further away in time from the mid-20th century until when we had a common legal system as a colony of Great Britain. As that time becomes more remote, we have both some loosening of that connection, although it remains entrenched in the English common law to a large extent, particularly in commercial fields where we have had relatively little statutory intervention. The other side of that, of course, is that with increasing globalization and international or transnational merger of the dispute resolution system, particularly when I say that, I think particularly of international commercial arbitration and mediation as the forums where these concepts, where this dispute resolution is really moving from very jurisdiction-specific resolution to a more globalized or transnational system of dispute resolution. We find opportunities arise for us to think in a much more common or collaborative way about the way forward. In India, this produces a particular opportunity, given that commercial dispute resolution has really grown manifold, both in quantum and in its complexity. I think over the last, I would say, perhaps 3 decades since we went through a very really game-changing economic reform, and particularly in the last decade, when we have introduced, both for domestic and international commercial disputes, a new statute and a new system of commercial courts which resolve those issues. I'm sure that those of you who are familiar with Indian legal practice in any way and will already know that perhaps the greatest challenge that we face in our legal system is of the volume of litigation that comes into our courts, and I don't think I betray a secret when I say the struggle of the judicial system or the legal system to cope up with those volumes and produce results as rapidly as we would like. The challenge becomes particularly acute when you think of an economy that is growing over the last decade at an average, I think, of 7% or so per annum. You have an economy growing at that rate, businesses growing at probably a rate higher than that. And resultantly, the number of commercial disputes and their quantum also coming to a proportion that is entirely different from what we are used to dealing with. It is not a new problem. It is one that we've been thinking about for a while, and it was first suggested in 2003 that we should have fast-track courts to deal with this. But that legislation, that suggestion of the Law Commission resulted in introduction of a bill which finally went back to the Law Commission and was finally passed by Parliament only in 2015 as the Commercial Courts Act. It envisioned the setting up of commercial courts, both at first instance and at an appellate level, to deal specifically with commercial disputes of a specified value. The specified value is actually much lower perhaps than it should be. But the real change that this introduced was in a generalist legal system to think of a specialized set of courts to deal with a particular kind of issue rather than the regular system of courts. I will explore in a minute or two as to whether that experiment has been as successful as we should have hoped. But it is really that is in my view the main motive of a legislation such as the Commercial Courts Act. The idea that you need to have expertise and specialization in a particular kind of dispute resolution to make that expeditious, effective, and economical for the user. The aims of the legislation were, of course, to be an engine of economic growth, to improve the legal culture of dispute resolution, and importantly, as if you think of one of 3 aims that a sovereign parliament should articulate, to improve the international image of India's legal and judicial system. Another aim, which is, or not an aim, but another tool really, which the commercial courts infrastructure has really sought to develop to a very large extent, is the use of technology in judicial work. You would appreciate in a country as large and diverse as India, it is the use of technology both at the very at a very sort of level of just video conference, having video conference hearings, having evidence recorded by video conference, etc., is in itself a huge step. It requires a commitment of time, effort, and resources that really have been deployed for this purpose. Our present Chief Justice, Justice Chandrachud, is particularly concerned that we should harness and use technology for judicial decision making in the best way possible, and I think that is the direction in which we are going. So with the Commercial Courts Act, which was introduced in 2015, there are 4 or 5 major reforms that it brought to the system of commercial dispute resolution that I would like to highlight for you. The first, which was actually introduced by way of an amendment a few years later, was mandatory pre-litigation mediation. So before a commercial dispute reaches a judge in court, the parties are obliged to explore the possibility of a settlement through mediation. This may seem like it is virtually a given that most commercial parties would like to explore. But in the Indian context, it did provide a new emphasis to mediation, because one was at the pre-litigation stage. So before you have seen a court, before you have seen each other's pleadings, make an attempt to see whether this is a dispute which can be resolved. For sophisticated commercial entities, I think it perhaps provides less of a difficulty, because they are in a position to know to a greater extent their legal rights and their likely liabilities. But when you think of smaller commercial disputes in a growing economy like India's, I think this has been a fairly important introduction. I hasten to suggest that, to add that in these last 6 years, we have found much greater success with mediation at a post-institution stage than we have at a pre-institution stage. But I'm optimistic in thinking that this is a transitional stage, and as parties get more used to the concept of settling even before you start a litigation, we will find greater success. The only, and this has been now established in a couple of decisions of our Supreme Court, the only exception is if interim relief is reasonably and urgently sought. So the court is required in deciding whether you can be exempted from pre-litigation mediation, not just to see that you have asked for urgent relief, but to examine whether that request was reasonable at all. That is, so that's one factor that has been introduced by the Commercial Courts Act that I think is a game changer. The second is the possibility of having summary judgment in all commercial cases. So a judge is not required to send a commercial case to trial if it appears to her that the matter is one which is capable of where there is no real chance of success on one side or the other. It is, of course, done on the application of one of the parties, but we still operate Civil Procedure Code of 1908. So with several amendments and modifications along the way. But the basic document is still one of 1908. And I think our system was getting a little over-reliant upon the procedural steps that a litigation, particularly a civil claim, must take. So this has also been a strong provision for our use. Of course, a much more robust regime of case management has been incorporated in the Commercial Courts Act than we were used to. I am not certain and haven't found even anecdotal evidence as to whether we are using it as effectively, but I think that's as we should. But that is perhaps still a work in progress. The two really procedural elements which have also been introduced in the Commercial Courts Act and have made a big difference, I think, are one, strict timelines for filing of documents, evidence, etc., and much more stern regime of costs. So these are both things which we have tried over the last 30, 40 years to implement without a statutory instrument. But I dare say we have not been as successful as we are now able to be with the backing of a legislative enactment. On both these, the Commercial Courts Act has laid down strict parameters for timelines. You would, again, appreciate that in a country where the judge is faced with a volume of litigation every day that he or she really cannot legitimately get through, the disincentive to refuse adjournments is really missing. And there is, so this provides a statutory sort of disincentive to grant adjournments and to insist that litigants and the court stick to the timelines that are provided. In the presence of lawyers with experience of the Indian commercial courts, I won't suggest that we have always been successful in this. There are times when they win and there are times when I win. But there is at least an effort in that direction. The costs are also really a huge issue. I mean, I can tell you that to an Indian lawyer and a judge even now, when we see decisions of your courts or arbitral tribunals, etc., and you look at the volume of costs or the quantum of costs that are awarded, it is not intuitive to us. Yeah. So you see cases, for example, and I don't suggest that it is unfair, but it is just surprising to us even now when you see cases where a side which has in fact been awarded a certain amount has to pay costs because they didn't settle at a higher amount earlier. And sometimes those, so we are trying, let me put it like this, that we are trying in some way to achieve a balance. We did not have aerial costs in an Indian court are regarded as a punitive measure. It is not, even though that culture is now changing, at least in the commercial courts, where we regard costs as just compensation for losing litigant to pay. So these factors and the reduction, both in the number of appeals and the kind of orders which can be appealed in a commercial court scenario, have proven to be very effective, in my view, in expediting the resolution of criminal cases. After the Commercial Courts Act in the last 10 years, we have set up as many as 1,252 commercial courts at the level of the district courts, 25 commercial divisions in the various high courts. and a corresponding number of appellate courts also in the commercial courts. We have, according to the data that we've been able to compile from the various high courts, about 70,000 cases pending in the commercial courts all over India. The numbers, to some extent, reflect the growing volume of commercial litigation. Speaking for the Delhi High Court, of which I am a part, we have now been able to achieve a situation in the last couple of years where we are at least meeting the institution of new cases in terms of the number of cases that we are able to dispose of in each year in the commercial courts. There has been some academic literature, although it is a little dated now, I think of 2019, which suggested that the first 5 years of the Commercial Courts Act were not very successful. And in fact, one of the articles I was reading this afternoon suggested that we had in fact become slower in disposing of commercial litigation in that period. That was, of course, followed by the 3, what I call 0 years of COVID, which we really can't count for statistical purposes, I think. And so now I would be intrigued to see, unfortunately, we don't have that kind of data available, but I would be intrigued to see in the next few years as to whether we have met the objectives of the litigation of the Commercial Courts Act in any substantive way. I would like to end, Master Reader, by just thinking about going back to where we started, which is to think of commercial dispute resolution as an area for collaboration and cooperation between our jurisdictions. In that, I would suggest that that opportunities such as this for exchange of ideas and thoughts, and for really both the judicial and legal systems to build stronger relationships with each other would go a long way. We have only, I think, maybe 2 weeks ago at a lecture in the UK Supreme Court, Chief Justice of India, Justice Chandrachud, spoke of the shared heritage which the English system and the Indian system share in the field of, in the context of commercial arbitration. And I would venture to suggest that the same really applies to commercial dispute resolution as well. At the level of the commercial courts, I think Master Treasurer would be aware of the Standing International Forum of Commercial Courts, which has been established by the UK judiciary and provides a hugely facilitative mechanism for judges from commercial courts all over the world to be able to interact and exchange ideas. I think I see anecdotally that is happening at the level of the bar as well, both with the rules. The Bar Council of India has come up with rules which permit foreign lawyers and law firms to engage in some limited spheres of legal advice and engagement in India. The Bar Council of India and the Law Society and Bar Council of England have also entered into a memorandum of understanding which facilitates the building of those relationships. There are, of course, lawyers with dual qualifications, including some of the very eminent Indian lawyers. 2 former Solicitors General of India are now barristers qualified in the UK as well. One, I think, practices Gopal Subramanian practices from Master Readers.
I had the pleasure of being led by Harish.
Oh, really? All right. So we have both the names I'm thinking of. A third example sits to my left in Chintan Chandrachud, and to my right is an example of an Indian senior advocate who is a door tenant in chambers in London. These are really examples and testament of the growth of this relationship between the two jurisdictions, and I hope we will see in some way an opportunity for that to happen with greater vigor and energy, and in both directions. So with these words, Master Reader, thank you very much for your attention, and look forward to any questions that you might have at the end of the session.
Jalan, thank you very much indeed for that. We now move to another senior advocate, Ritin Rai, who is going to tell us about practice as a senior advocate at the Supreme Court of India.
Master Reader, thank you. The other masters of the Inn, Justice Jalan, my co-panelist Chintan, if I may, ladies and gentlemen. It's really a privilege to have been invited here to speak today. And I was actually at my chamber, 7 Kings Bench Walk, and they told me about this lecture theatre, which is newly built, and it's a delightful space, and I'm very glad to be speaking today. I think between Master Reader's one comment about Indian senior advocates perhaps not staying with the script, and then Justice Jalan's longer address on how commercial litigation has evolved in India, I think that really sets up some of the context on which I'll talk about what it is like to practice as a Supreme Court, as a senior advocate in the Supreme Court of India. I was speaking just now with a member in the audience about the process of designation, and perhaps I should just spend a minute or two on that, because it is slightly different from the manner in which you make silk in this country. In India, you get designated as a senior advocate by our constitutional courts, either by the high courts across the country or by the Supreme Court of India. And although you start your life in India as an advocate, which means you can practice either as a barrister or as a solicitor or both, which is to say you can file a case and argue it yourself or instruct someone to argue it, or you can choose to file and argue your cases yourself. You decide through the initial phases of your career whether you would like to practice as a solicitor more or a barrister. And if you feel you have developed a practice as an arguing counsel, you could apply to the court for designation as a senior advocate. And that is now an application you make to the court, which is scrutinized on some objective parameters of the work you have done, perhaps the articles you have written, the cases you've appeared in, followed by an interview. In the case of the Supreme Court, the Chief Justice and the 2 most senior judges, along with the Attorney General and 1 member of the bar, a 5-member panel interview you, and thereafter the full court of that court, the full court of the Supreme Court, which is a little over 30 judges, votes on the applications. So our application process is a little different from yours, and the judges who you appear before regularly are the judges who determine whether you are worthy of designation. So I just thought that's something that's been quite instructive to me about how the process works here versus how it works there. In terms of practicing in the Supreme Court, it is not said without reason that it is one of the most powerful constitutional apex courts in the world. The range of cases that the Supreme Court deals with is perhaps wider than many other jurisdictions. And then just to give you a recent example, of course, we had our national elections a month ago. A recent case that the Supreme Court dealt with was the manner in which political parties can receive funding. The government had introduced a policy of electoral bonds that was challenged in the Supreme Court of India. And just a few months before the elections, the Supreme Court held that policy had to be struck down and directed certain disclosure of funding made to political parties, a judgment that has far-reaching consequence and is an example of the kind of public law, constitutional law cases that the Supreme Court deals with. But it deals with a lot more than that. I mean, I've been in England for the last 2 weeks, and my city, Delhi, has been obviously suffering under this heat wave. There's been a little water crisis. The Supreme Court has been asked to intervene by the Delhi government as to why neighboring states are not releasing water to the city of Delhi. That's again an example of the kind of reach of the cases that the Supreme Court routinely deals with. And then we had the interesting one where our national elections were held. Exit polls gave the incumbent government a very strong majority coming in, which proved to be a little inflated when the numbers were finally counted. So we've had public interest litigation in the Supreme Court directing that there be an inquiry into these exit polls because there was a lot of the movement in the stock markets, and so whether this was a stock market scam. But again, that was a direct public interest litigation filed in the Supreme Court of India for that kind of a matter. I think Justice Jalan could also speak perhaps to, during COVID, we had very active courts pushing the executive to take measures in favor of the citizens to ameliorate the problems that were being faced by COVID. But that's on the Constitutional Court of the Supreme Court and its public interest litigation jurisdiction. Apart from that, the Supreme Court is a regular appellate court. All manner of civil disputes, service law cases, criminal law cases, and commercial law cases come to the Supreme Court by way of appeal from lower courts or tribunals. What's, I think, been a little trend in the last several years is that counsel are now specializing in areas of law. I think whereas maybe 2 decades ago you wouldn't have found counsel specializing in areas of law, now with the increasing complexity and sophistication of laws, you see counsels increasingly specialize. And you cannot talk about the Supreme Court without speaking of the sheer volume of cases that the court deals with. Prateek's given us some of those numbers, but the Supreme Court deals with a staggering number of cases on a weekly basis. And practicing as a senior advocate in that court, or indeed in courts in India generally, again, something that is very different perhaps from a King's Counsel here or a barrister here, is we are in court almost every day arguing cases. So we are in court almost every day arguing cases and on several days arguing multiple cases. Coming to my area of commercial work, which is, I think, more what the audience also deals with, the kind of commercial work that comes to the Supreme Court of India is not just commercial suits. Justice Jalan spoke about commercial suits. And commercial suits sometimes come to the Supreme Court after 2 or 3 courts have heard the matter. But the Supreme Court also deals with a vast array of laws for which we have constituted specialized tribunals. Outside our traditional high courts, we now have specialized tribunals that deal with areas of law. So, for example, in regulated sectors like electricity or telecom, we have a separate appellate body for electricity or a telecom dispute settlement appellate tribunal. Cases of telecom law go directly to that tribunal, not through our traditional court structure, and appeals from that tribunal go directly to the Supreme Court of India. And in addition to regulated sectors, we've got specialized areas of law, so company law or competition law, insolvency law. These go to a tribunal called the National Company Law Tribunal, and appeal from it goes to the appellate tribunal and then again directly to the Supreme Court, not via the High Court. What all that has done, if I can try and sort of say it in 4 or 5 trends that I think. One trend, given this kind of workload, has been the increasing digitization of our work, the increasing use of technology. I was doing a matter in the Delhi High Court with counsel who were coming to the court from London. They were coming to Delhi, and even pre-COVID, they were quite amazed by how much our Delhi High Court was using technology. And that use has just galloped post-COVID. Justice Jalan spoke, of course, about virtual hearings where we can address the court virtually. But it has now gone through many more changes in our courts, where today the court and the lawyers have access to the same file. You can go to the court website and see the latest filing made in your particular case in real time. And now, of course, if you appear in the court of the Chief Justice of India and you tell him or you tell the bench to go to a particular page, the Chief Justice will ask you for the PDF page number. And if you don't have the PDF page number, you're on a different page from the court, because the court is reading off a screen and has made available to all the lawyers that same filed version where all of you can be literally on the same digital page. The second trend, again stemming from the sheer volume of cases that the judges are doing, is the increasing emphasis on written submissions and timelines for counsel to address the court. Timelines is a work in progress. I think even in the last 5 or 7 years, I would say, where timelines were very stretchable by counsel a few years ago, they have now become stretchable. But it is that process of transition where you can see how we are moving to a better system of even oral advocacy, and particularly written advocacy as well. I think the judges are now increasingly asking us to come to court with skeletal submissions, and increasingly asking us to refer to our skeletal submissions while we are advancing oral arguments. They, again, allow us to supplement that with closing submissions after we finish our arguments. Again, it's a transition, but you can see that efficiency coming into the court. The third fact, though, is that given the sheer diversity of the cases the court is dealing with, there will always be some concern about whether our commercial cases are moving quickly enough. But again, I think we have to see this from the perspective of the system that is dealing with cases of criminal law, of human rights, and they cannot simply prioritize commercial cases, no matter how high the value is. So that balance is, of course, being struck by individual judges and courts on the basis of looking at the entire workload of the court and trying to allocate as many resources as are appropriate for commercial cases. But certainly that is a challenge given the sheer number of cases that the courts deal with. The fourth trend, again stemming from the workload the court has, but the increasing sophistication of our laws, is the Supreme Court deferring to specialized tribunals or decisions of arbitral tribunals. You will increasingly hear a court saying, well, you've got a specialized tribunal dealing with this subject. We are going to defer to that specialized tribunal's decision on this. We can't second guess it beyond a point. And that's important because often these are first appeals going to the Supreme Court from that tribunal. And whereas earlier, as a matter of right, you would have notice issued, a whole argument again at the Supreme Court, today you're seeing the Supreme Court trying to see whether the matter really requires consideration or can be dealt with at a very initial stage of the proceedings. And that deference to the specialization is particularly in the cases of arbitration awards as well. There is increasingly a statement made to counsel that you parties chose to have your disputes redressed through an arbitration. You've challenged it in the High Court. You've had a first appeal in the High Court. We really can't entertain you in a special leave petition in the Supreme Court. And that's true even, for example, when there's enforcement of an award. And if the court declines to get into the reasons for enforcement, the first appeal lies to the Supreme Court of India. You see on day one, the Supreme Court dismissing such appeals. So that's, again, a very positive trend. Again, Master Reader spoke about how different cultures start perhaps from the same place or the same legal provision and interpret it differently and at a little variance from each other. The Supreme Court looks a lot at case law cited from jurisdictions outside India. They do that also in commercial matters, but very, very mindful of the local law itself, the municipal law that it is dealing with, and also to some extent the culture of that country. Again, to take a recent example from arbitration law, there is this huge debate in arbitration law about to what extent you can bind non-signatories of an arbitration agreement to arbitration proceedings. and there's the group company doctrine, rejected in large measure in this country, the Supreme Court of India has accepted that doctrine. While even referring to foreign jurisdictions which do not accept the doctrine, the Supreme Court finds it has great utility in the Indian context. And so, taking a pragmatic approach, the Supreme Court has reaffirmed that group company doctrine. Again, you see the court looking at local factors and interpreting, or looking at foreign law as well, but interpreting the Indian law by itself. Again, perhaps stemming from Justice Jalan's last comments, a word or two about the role of foreign counsel in Indian proceedings. I was a counsel in the case involving whether foreign lawyers can practice in India. And the Indian court, the Supreme Court, has said that they can practice arbitration law in India. They can appear before arbitral tribunals. So in terms of courts, of course, foreign lawyers can only advise, as perhaps you have done, Master Reader, on occasion. But that advice is increasingly being sought in cases that have a multinational context, in cases that have implications outside just the Indian jurisdiction. And there, of course, foreign lawyers are sought and their views are taken into account, although, of course, it is only the Indian advocate who can address the court. But in arbitral tribunals, at least in my practice, I see very often a co-counsel role, where even if the matter is an Indian law-governed arbitration, you may have an English barrister advancing arguments and an Indian counsel also advancing arguments on Indian law. And perhaps that's also because the Indian senior advocates typically practice as appellate court lawyers. And so maybe there is a feeling that the trial of the arbitration can be conducted by a co-counsel who is English trained, and you could have a co-counsel who is also an Indian lawyer. So there's great opportunities for cooperation as our economy grows. I mean, Justice Jalan has given you the statistic, but it's just fair to say that over the next 2 decades, this economy is going to grow and is going to be increasingly sophisticated in its understanding of laws, and is going to reach out to jurisdictions that have already dealt with similar issues. I'll stop there and look forward to any discussion after the panel. Thank you.
Thank you very much. Chintan, before we move to questions, it's now for you to talk about arbitration, please.
Yes. Master Reader, Honorable Justice Jalan, Ritin Rai, Senior Advocate. Many thanks for inviting me to speak at this panel. It is indeed a privilege to share a panel with such esteemed panelists. No panel about India is complete without a cricket analogy, so let me take a stab at one. Being in my position, that is the third speaker this evening, is the equivalent of coming into bat after Joe Root and Kevin Peterson have been dismissed. So I'm going to keep my comments rather brief. What I'm going to speak to you about today is India-related arbitration seated in England. And the context to that is that a substantial proportion, I wouldn't say a majority, but a substantial proportion of my work in this jurisdiction involves arbitration that is seated in London or in England, but has some India connection. And by that I mean Indian parties and or Indian substantive governing law and or Indian assets or Indian property. And I thought it might be useful to talk you through some of the challenges or issues that I've encountered during the course of that practice over the last few years. And I've identified 5 issues in particular, going through the life cycle of an arbitration, as it were. So the first goes to appointments. And I think until not so long ago, there was an assumption amongst Indian clients, Indian parties, that in order to have a seat at the table and in order to be heard at the arbitral table, one couldn't appoint an Indian arbitrator for whatever reason, perhaps because the perception was that Indian arbitrators lacked the kind of experience that arbitrators from other traditional arbitration-friendly jurisdictions possessed. I think that has quite happily changed over the last few years. So that within commercial arbitration, at least my experience has been, and in fact, I don't think I've done a single commercial arbitration involving India that doesn't have an Indian arbitrator. So it's changed when it comes to commercial arbitration. But oddly enough, that change, I haven't seen that change when it comes to investment arbitration. And I suspect that part of the reason for that is that, again, there's a perception in the market that there isn't sufficient investment arbitration experience amongst Indian arbitrators. And so now you see a divergence between commercial cases on the one hand and ISDS cases in the other, where you'd routinely find Indian arbitrators, former retired High Court judges, Supreme Court judges appointed in the former, but not so much in the latter. Now, don't get me wrong, I'm not suggesting that it is always necessary or appropriate for an Indian party to appoint an Indian arbitrator. Of course not. I mean, it may well be appropriate to appoint an arbitrator from another jurisdiction because of technical expertise, experience in the area, etc. However, I have done a number of cases where I've found that having an Indian arbitrator, that is an arbitrator with the Indian cultural background, can make a difference. And I'll give you a simple example, a couple of examples. Everyone knows, of course, that India is the most populous country in the world, that its population is 1.4 billion people. But what people that don't have necessarily the cultural experience of living and working in India don't understand is what that actually means in practice. How that percolates and how that influences the way in which governments, state-owned entities, and for that matter, even private corporations operate. And so one thing I've seen in my practice, for example, is that it has sometimes proved challenging to explain to an arbitral tribunal why you need 20 client representatives sitting in the hearing room when your German counterparts need, for example, just their general counsel or perhaps their CEO and their general counsel. So just explaining those cultural nuances can be much easier if you have someone at the table that has the experience and can bring it to bear. Just another example, since Ritin was talking about Supreme Court practice. The UK Supreme Court hears, on average, about 80 cases a year. In the Indian Supreme Court, on Mondays and Fridays, every bench of two judges hears 80 cases. And so if you add that up, you get somewhere between 70 and 100,000 cases a year. So we're talking staggering differences in numbers. And to my mind, that actually percolates and has a trickle-down effect in many areas when it comes to kind of disclosure, custodians, who can attend, the number of witnesses, and so on. In that context, I think it's worth mentioning that quite recently, a group of lawyers in London predominantly, but also from elsewhere, have established something known as the India Promise, which seeks to increase the representation of Indian arbitrators in disputes involving India. And I think that that's certainly a welcome initiative because a substantial proportion of international arbitration cases now do have an India connection, unsurprisingly, given the size of the Indian economy and so on. And so I think it's only natural to see an increase in the number of Indian arbitrators going forward. The second point, the second challenge that I've seen in my practice is this question of pleadings versus memorials, which you encounter inevitably in the early stages of an arbitration. And I think that is an area where the international community, particularly the arbitration community in London, may have something to learn from the Indian arbitration practice. I think there is an embedded assumption in London and in other arbitration-friendly seats that unless the parties agree to go with pleadings, the default position is memorials. And I don't think that assumption is necessarily appropriate. I've seen a number of cases, for instance, where the memorial-style approach has been adopted. Both sides instruct experts in a number of fields, foreign law, technical issues, etc. And when you actually get close to the hearing, you realize that there was a large measure of agreement and that those costs and all of that time has just been wasted. So I don't necessarily think that memorials is always the right way to go, but I found that there's an assumption in London in particular that that's how things are done. Third point which I'd like to address is disclosure. And again, this is one of those areas where there is a significant divergence between the Indian and the English legal systems. Now, although India is, in principle an adversarial legal system, the way in which commercial litigation for the large part is conducted in India is that you run and you present your case based on the documents that are in your possession. Unlike in England, of course, where you plead your case based on the documents in your possession, but you present your case based on a larger body of documents, including documents that have been disclosed. It takes a long while to explain to Indian clients what a robust disclosure exercise entails. And the only advice I'd have for any of you that are involved in India-related arbitrations is to start as early as possible. But that's the best that I can give you. Point number 4 goes to settlement. And it's a subject that Honorable Justice Jalan also addressed in his comments. I found it particularly difficult to get traction with Indian clients to either to come to the settlement table or to give or to accept an attractive settlement, what seemed to me to be an attractive settlement offer. And I conducted a straw poll at the London International Disputes Week a couple of weeks ago amongst lawyers that represented particularly Indian government or Indian state-owned entities. And the majority opinion was that the reason for the reluctance to make or accept even a good settlement offer is a fear of consequences, i.e., what will happen down the line if someone somewhere decides that this was a settlement offer that was much too lucrative for my opposing party. So I would rather take the chance of losing the arbitration, losing lots of money, losing my legal costs, but delegating the decision to the arbitral tribunal, i.e., it's not my decision, than taking the responsibility for making the decision myself. Now, I suspect that there's no easy solution to this problem. There are already policies out there that seek to kind of move away from this problem by encouraging officers in various government departments or in public sector entities to accept appropriate and attractive settlement offers. But I think further progress needs to be made on that front. Finally, and I think related to the point that I've just been discussing, is a tendency to run points with low prospects of success. And I think that the reason for that tendency is again much the same, i.e., I'd rather not take the risk of abandoning a point early in the game. And so let's run grounds 1 to 100, even though I know that grounds 11 to 100 are terrible and barely arguable, and defer the decision of whether to abandon 11 to 100 further down the line. Again, I think a combination of some policy changes together with perhaps a shift in thinking, a cultural shift, can perhaps result in a change in approach. Now, I would be remiss not to mention a recent development that's occurred. So this is just from 2 weeks ago. It's an office memorandum that was issued by the Ministry of Finance of the Government of India, which I think on balance, in my view, is somewhat unfortunate. And what the office memorandum says is this. It discourages, to put it mildly, arbitration clauses in contracts in respect of arbitrations in relation to high-value disputes, and high value is defined as disputes of a value of 10 crore Indian rupees or more, which roughly converted is roughly £1 million or more. And peculiarly enough, although I do agree with much of the office memorandum is essentially a critique of Indian arbitration and the way in which Indian arbitration law and jurisprudence has developed over the past decade. And although I agree with a substantial proportion of that critique, I don't think that the solution is to move away from arbitration. I think that the solution is to fix arbitration. I'm optimistic, however. I don't want to end my discussion on a note of pessimism. I'm optimistic that this will not be the last word on the subject, because the stage at which it's presently at is a direction to various government departments to change the clauses, change what they agree essentially in their contracts. And I'm hopeful that there will be an opportunity in the next few months, and if not the next few years, to course correct before we see very different looking dispute resolution clauses in Indian contracts. But I'll stop there. Many thanks to everyone for your patience.
And now, time for questions. Yes. Bonda, have you got the microphone?
Thank you very much. That was a very interesting set of talks. I have a question about settlement, something picked up by Justice Jalan and also by Chintan. And I'm interested in mediation. And in the UK, we now have a very developed mediation structure. When I started at the bar, we didn't. That was 1995. But now we have lots of mediators in lots of different areas. I'm interested in how sophisticated you think the mediation market is in India at the moment, and perhaps walking on brittle glass, to what extent do judges get involved in mediation? We have judicial mediation here. We also have private mediation. Both systems are very sophisticated, and I'd be interested to know what the Indian model currently looks like.
Okay, so I think mediation has. Sorry, I don't think. Sorry. So, Tom, I think mediation has certainly grown in India over the last 10 to 15 years, particularly in commercial disputes. In fact, one of the things that Chintan just mentioned at the end of his talk was about a new government instruction not to have arbitration clauses. But that very same instruction says, instead, please incorporate mediation clauses so that you will end up settling disputes and ultimately you will have a final say in how the dispute settles as a government or government entity, rather than leaving it to arbitrators. I know that speaking of court-annexed mediation centers, we've had great success both in the Delhi High Court and in a number of other commercial courts particularly. Parliament has just enacted a mediation statute which deals specifically only with mediation. As far as judges are concerned, their involvement, I think, tends to vary. My own experience is that I'm terrible at it. Perfectly happily married couples come into my chambers and leave divorced. So that is the. But there are colleagues who are really good at it and do manage to sort of achieve settlement with their own intervention. My own experience, and maybe because of that, is that it is that sometimes if you explore that as a judge, then it becomes difficult, I won't say impossible, to actually adjudicate the case if the settlement fails. Because parties have a notion of what you are thinking. You have a notion of who's fair and unfair, however much you might try and remove that from your consideration. And confidences have been shared, which should not be shared with the judge. So the judge's role, I think we are still working on that a little bit. The mediation regime on the whole, I think, has really taken off in a big way. Unfortunately, helped both by the great incentives that it offers in terms of a mutually beneficial resolution, and also by the disincentive of having to remain in court through several years and layers of appeal. So both, and it's sometimes difficult to distinguish which of the two really motivates parties, but I think have contributed to a very very significant mediation culture developing in India as well. I don't know if Ritin or Chintan would like to add anything to that.
Just very briefly, as Honorable Justice Jalan was mentioning, the office memorandum that I referred to does encourage parties to either agree mediation clauses in advance or mediate even in the absence of a contractually agreed mediation clause, which of course I welcome. Equally, I think the point that it misses is that mediation and arbitration are not mutually exclusive. I mean, you couldn't have a jurisdiction clause in favor of the Delhi court plus an arbitration clause in the same contract. It wouldn't really make sense. But you could have a mediation and arbitration sort of layered dispute resolution clause. And I'm hoping that that's where we march towards in the near future.
Master Fleisch.
Good evening, and thank you very much for a wonderful talk. I should just say in parenthesis that I was called in Bombay in 1980. One or two of you may even remember the incident. And I have conducted litigation in India. May I say how wonderful it is to hear and indeed experience the changes that have taken place since then. I've found in 1980, when I was conducting litigation, and I have conducted specialist litigation in the intellectual property area in Calcutta, Delhi, and Ahmedabad and Bombay, that I was a square peg in a round hole in many ways. But gosh, haven't things not changed? They really have. And I tell my English friends, well, when I became a judge particularly, how Indian judges can get through these lists. I just, it beggars credence to go on a motion day in the Delhi High Court and watch this. I think you should all be canonized, or whatever the right word is, or sanctified for what you do. But I have a question, or two points, one for Dr. Chandrachud as well. First of all, on the specialist court area, I know that there are one or two judges, and Justice Jalan's colleague, Prateek Singh, whom I well know, is one of them, with great experience in IP. How are we getting on with an IP court? That's my first question. And secondly, for Mr. Chandrachud, Doctor, sorry, I've done a couple of mediations, because after leaving the bench, I qualified as a mediator. Indian mediations, and I found the problem was a cultural one. And I need say no more if I just say the family, particularly, and I better be careful here, female members of the family. Right, thank you very much. That's the problem.
Shall we try the first question then? Do you have a specialist IP tribunal?
So we've actually done away with it, Master Faish. And may I just start by saying apologies for failing to recognize you. I was one of the young lawyers in the Calcutta High Court who was observing your your appearance before Mr. Justice Umesh Banerjee in the division bench sometime in the late 1990s, and we were all taken by the thought that an English QC, as you then were, had come to Calcutta to argue a case before our court. So I'm one of those observers who had nothing to do with the case, but was just making the atmosphere even more crowded and probably warmer than it should otherwise have been. So thank you very much for your presence this evening. As far as intellectual property is concerned, we did have an intellectual property appellate board till recently, which decided appeals from issues of trademark registration, copyright, etc., and patents, of course, which is the growing field. That has now been done away with. But we have tried in many of the high courts, mine I proudly say being the first, and Pratibha Singh, who you mentioned, having been instrumental in that, to set up specialist intellectual property divisions within our commercial court. So we have now, at least for the last 2.5 to 3 years, we have 2 or 3 judges who do only intellectual property work. They decide both suits that come to the court, infringement or patent suits or other things, as also appeals from trademark registration decisions, patent registrations, etc. So we don't have a specialized intellectual property tribunal anymore, but we have tried to devote resources within our high court system to intellectual property cases. More than one court has now adopted the same system, and I think it's working quite well in what is, of course, another growing area of litigation for us. Thank you.
Thank you, Master Jalan. Just to turn to Master Fleisch's second question, I have to say my own experience, which chimed with Chintan's experience of attempting to reach settlement in relation to Indian-related litigation, particularly against Indian state banks, was twofold. First of all, no one wanted to be responsible for the decision because they were worried, as you say, that someone... the second one came from what I gather is changing now, but the fact that litigation in India, how can I put it, takes a generation or so to come to a conclusion. And therefore, there's an element of, well, the result is fate. It is not, it's not a process that I am engaging in order to reach a result, because eventually it will happen probably to people one generation after mine, or possibly in commercial cases, 2 or 3 appointments after mine, whatever, and therefore I'm not really concerned with the result, merely in ensuring that no blame attaches to me while it's going on. Is that a fair summary of how it seems at the moment?
Yeah, I think that's right. I mean, for commercial disputes particularly, that is a very fair summary. And just to add to what Chintan said earlier, is costs. Costs are not a sanction in our courts, as Justice Jalan said and Chintan also said. So there is no incentive to settle, because even if you do not settle, you are not going to face costs at the end of the hearing if you fail. So I think just to add to that cost is also a factor. And if you had costs staring you in the face for an unmeritorious claim, you might be able to settle a little quicker. But certainly the other concern for an officer, particularly in a state entity or a state itself, is, while I hold this office, let no decision be taken lest blame also fall on me. So let me just shepherd this case to the next person.
May I just take a moment on that?
Yeah, of course.
So I would only add to that that I have, again, the eternal optimist. I have seen the first rays of sunshine. In the recent past, I would say maybe 12 months or so, there has been, even with state-owned entities, a greater sort of propensity to arrive at settlements. And what is, I think, an interesting via media that is being used, which is actually having objective criteria. So, for example, there was a scheme recently which encouraged settlement at a proportion, at a percentage of whatever was the arbitral award. So if either you had challenged the arbitral award as a state-owned entity or the other party had challenged it, the party could make an application and say, I'm willing to settle, I think it was at 60% of the award amount. And there was no discretion. So as long as you met the conditions of the scheme, the settlement would go through. The interesting nugget here is that it is then not fact-based and not discretionary. That removes this level of fear or apprehension from the mind of the decision maker, because the higher level decision maker has made a fact-agnostic decision that we need to get rid of commercial litigation of this sort. On the whole, historically, I'm assuming they did some empirical research, although maybe that is also an optimistic assumption, that we managed to recover about 60% of what is at stake. And therefore, if people are willing to settle at 60%, do it and finish off the litigation. That scheme was actually quite successful and has ended some of the litigation that would otherwise have been bequeathed from one generation to the other. Some of the big litigating parties, we have huge highway construction projects going on in India at the moment, and the authority that is responsible for those seems to have taken a decision to, I'm not clear how they have managed these issues of which have rightly been highlighted by everyone else. But there does seem to be more of an instinct to arrive at a commercially viable solution, even at the cost of some sort of apprehension of one's own future. So there has been the first rays of change around the horizon.
There's a question over here. Yes.
Thank you very much. It was a very, very interesting presentation. I learned a lot. I have two questions, very brief. One about timing and the other about disclosure. In relation to timing, Jeremy Bentham wrote an evidential treaty on 5 volumes on evidence in which he presented us with his theory of procedure, saying that the main purpose of procedure is record of decision without excessive delay and cost. Adrian Zuckerman used Bentham in assisting Lord Woolf in a major reform in this country in the 90s. And so my question in relation to delay or the dimension of timing is, how long does a commercial ordinary proceeding takes from the day in which it's filed on the first instance commercial court, goes through the appeal, reach the Supreme Court, and the Supreme Court deliver a judgment? That's the first question, if you have the data in an average. And the second question is about disclosure. Is there a positive legal obligation on a party to disclose adverse material? Thank you.
Now, on the first question of timing, I think it's very hard to say what is the length of a commercial suit from first adjudication to appeal to Supreme Court. But just to show you the change, in our Arbitration Act, a timeline was introduced for the completion of the arbitration proceedings. And it said it must be done within 12 months of the constitution of the tribunal, which then changed to completion of pleadings. But a 12-month guillotine was put. Parties could agree for a further 6 months, and after that they had to go to court to explain why the award hadn't been rendered in a period of 18 months. And when this first was introduced, many of us thought it is not possible that we will be able to achieve that in India. But actually it has worked. It may not again have worked to have the exact limit of 12 plus 6. Some arbitrations do go on longer, but over time we are seeing it working. And for example, a second change in the Arbitration Act was when you challenged an award, there was an automatic stay on enforcement of that award. That position has also been reversed. So today, even when you challenge an award, the award can still be enforced, absent you getting a stay on enforcement of the award, which is usually on a deposit of a significant part of the award amount. So when you talk of commercial matters in India, the vast majority of contractual disputes, high-value contractual disputes, are actually settled through an arbitration clause. And at least in the arbitration context, we can say we have quite a finite time period for the arbitration process and some solution in terms of what happens even if the appeal process or the challenge process continues for a long period of time. The party can still probably receive some part of the award amount even while that challenge is pending.
Ritin, am I right in thinking that in the period just before the pandemic, the approach of the Indian courts to arbitration underwent quite a major change? You had a new Arbitration Act and decisions from the Supreme Court, which meant that arbitration didn't inevitably result in the case then being bogged down in the Indian courts on appeal and an automatic stay. Yeah. But actually the idea was that the arbitration should itself be the decision-making, and appeals would be more difficult and wouldn't result in automatic stays.
No, I think that's exactly right. And, the impetus for that is again coming from the sheer volume of cases that the Indian legal system is dealing with. And so if you look at our arbitration reform over the past decade, the few years before the pandemic, so 2014-15 amendments, you'll see the judiciary, the executive, and the legislature all motivated by the same concern, to give a fillip to arbitration. So you'll see that in executive instructions, you'll see that in the change in the law by the legislature, by parliament, and you will also see that in Supreme Court decisions, which all are trying to say, if we can resolve these big private contractual disputes through arbitration, that's that much time we can spend on other work in the courts.
And as to the second point, I think the difficulty is not so much the absence of a positive legal obligation. I think there is a positive legal obligation, although I can't point to it. I'll have to go and check. I suspect the problem is the divergence between theory and practice. I have been involved in a number of cases myself where there has been concern that documents have just simply not been preserved. They've been destroyed. Intentionally or unintentionally. They've often even, I've heard of documents having been destroyed in apprehension of litigation. And so in a sense, having an obligation to disclose documents is meaningless unless you actually comply with the prior obligation to keep the documents in the first place. And that's where I've seen the difficulties usually arising. Yes, it would, and it could result in very serious consequences if, for example, a legal professional was involved. I suspect that, there isn't as much of a fear of consequences in India. Yeah.
Yes.
Thank you. I've got two questions. The first one is to Dr. Chandrachud, Chintan Chandrachud. The civil procedure rules in the UK force parties to settle their disputes before court hearing takes place. In fact, it even disincentivizes parties if they do not settle their disputes when a valid offer is made. We have similar thing in India through the Civil Procedure Rules, Section 89, which talks about attempting to settle matters through alternative dispute resolution. Personally, I feel the Indian Civil Procedure Rules is not as strong as the Civil Procedure Code here in the UK, and I want to know what your view is on this. My second question is to Ritin Rai, Senior Advocate. Traditionally, the Indian courts have been more willing to intervene in arbitration awards, unlike the UK courts. Which system do you think has been more beneficial to the parties in giving the best outcome to them? Thank you.
Well, let's start with the first question, Chintan.
Sure. So again, actually, my response is similar. I don't actually think that there is a great divergence in terms of the positive law or the black letter law within both jurisdictions. In fact, Honorable Justice Jalan was just mentioning that there are provisions within the Commercial Courts Act that require, now of course you can't require parties to settle, but you can require parties to think about settling and to consider seriously whether or not to settle. And there are provisions that mandate pre-litigation mediation, pre-litigation settlement and the like. So I don't think that the problem is necessarily the absence of a legal framework. It's the fact that attitudes need to be brought up to speed with the framework that already exists and is in play.
You're going to deal with arbitration appeals.
Yeah. No, you're right. I mean, I think historically our courts were more likely to intervene and set aside arbitral awards. But again, I think if we look at the more recent jurisprudence and the changes to the Act, you see that the grounds to challenge an award have been more limited, and that courts are actually respecting that limit or applying that limit a lot more. So I think you're seeing less and less awards being set aside or intervened with by courts, and I think that's a good thing. If we have to go by the party's decision to arbitrate and keep the decision outside the court's remit, that has to be the correct approach.